Corruption and hypocrisy ought not to be inevitable products of democracy, as they undoubtedly are today. Mahatma Gandhi. When the Indian Penal Code was enacted, it also prescribed punishment for the offences of bribery and corruption amongst public servants. However, during World War II, it was realized that the bribery laws contained in the IPC were not adequate to meet the exigencies of the time. Hence, an imperative need was felt to introduce special legislation to eradicate the evils of bribery and corruption, and thereby the Prevention of Corruption Act 1947 was enacted, which was later on amended twice, once by the Criminal Law Amendment Act 1952 and later in 1964 by the Anti-Corruption Laws Amendment Act 1964, based on the recommendations of the Santhanam Committee. In spite of the 1947 Act being amended, it was still found to be lacking to deal effectively with the offence of corruption. To make the anti-corruption laws more efficacious by widening their coverage and strengthening the then existing provisions, the Prevention of Corruption Act 1988 was passed by the Parliament.
As we Indians take the privilege in our journey of 75 years of independence, Sansad TV contributes to the said phenomenal journey by dedicating a series titled 75 Years Laws That Shaped India. I'm your host Hemant Batra, back with another episode in that exclusive series. Today we are discussing the Prevention of Corruption Act 1988. To talk about this revolutionary legislation, we have with us a very learned expert panel. We are joined by Justice Pankaj Naqvi. Justice Naqvi, former judge of the Allahabad High Court, where he authored some landmark judgments, including the ones dealing with free speech, liberty, human dignity, and privacy. Post his retirement as a judge, he stands designated as a senior advocate by the Supreme Court of India. Welcome, Justice Naqvi.
Thank you. Thank you so much.
We are also joined by Kulbir Krishan, a highly accomplished former IPS officer who has been DGP as well as Chief of the Anti-Corruption Bureau. Currently, he is the member of a very significant National Security Advisory Board of India. Welcome, Kulbir ji.
Thank you.
Welcome, both of you, to the Sansad TV studios. So let's move on with our discussion for today. Let me come to you first, Justice Naqvi. Justice Naqvi, this law deals with corruption, bribery, or let's say bribe. To my understanding, there existed already a set of provisions dealing with these menaces. There were sections 161 to 165A in the Indian Penal Code, which have since been repealed. Then we had 1947 Act, which got amended, rather, I would say updated on 2 or 3 occasions. And now we have 1988 Act, which we are discussing today. Can you please tell our viewers about the efficacy and significance of this particular law, which was introduced in 1988?
You see, the Prevention of Corruption Act of 1947, as we all know, was an outcome of the World Wars. Because the World War had impacted the economy of many countries. And therefore, it gave a precursor to the public servants to resort to corrupt practice. So against this backdrop, the Parliament then enacted this 1947 statute. This statute continued for almost 40 years. Now, in these 40 years, the Parliament realized that, well, with the passage of time, the ingenuity of a criminal mind has also devised new ways and techniques. उन्होंने नए तरीके निकाल लिए to how to commit a corrupt practice and yet get away from the clutches of the law.
Right.
I'm focusing on passive bribery because passive bribery was absolutely unknown in the 47 Act.
Absolutely.
So taking cognizance of these issues,
right.
the Parliament in the year 1988 enacted a comprehensive legislation taking care of all these issues.
Right. Changing needs of the time and
certainly
and
it had to change.
Absolutely.
And that is where the Parliament enacted a much superior act which can take into competence any other eventuality as far as corruption is concerned.
Right.
Now the highlight of the 1988 enactment are, number one, the word public servant, because the act focuses on public servant,
absolutely,
has been very exhaustively defined.
Right.
As compared to 47 Act.
Right.
Secondly,
the definition was enlarged.
Yes. Secondly, earlier in the 47 enactment, the definition of section 161 to 165A, the IPC offences relating to bribery of a public servant, were incorporated. Were not incorporated, were just referred that if you commit an offence under so and so, you can be prosecuted under the PC Act of 1947.
Absolutely.
What has been done under the 88 Act is this, that those provisions have been incorporated
in this Act.
In the 1980 Act,
yes.
Their scope has been very well defined, so as not to leave any ambiguity.
Right. So so this Act is all comprehensive, all inclusive,
all comprehensive
in that sense.
Another notable feature is with regard to retirement. The 1947 Act focused only on serving public servants, whereas the 88 Act focuses both on serving as well as retired.
Right.
Another area of superiority of 1988 enactment is that the maximum punishment under the old Act was 5 years, so they had to make it a more deterrence. Now they have enhanced to 10 years.
10 years. Yes.
Another
more stringent and...
Another notable feature is that now special courts have been established which deals with these offences, and they are expected to conduct speedier trial, jaldi muqaddame tay ho, jaldi conviction ho, so that a message goes in the society that all this will not be tolerated. And the outer limit for conclusion of the trial is 4 years.
4 years. Right.
And other notable feature is that superior courts, because see, what happens in Indian judicial system is that a lot of interim orders are passed, as a result of which the trial gets obstructed. Now the superior courts have been restrained from passing any interim orders. But obviously this embargo would not apply for constitutional courts.
High Court and Supreme Court.
So these are some of the notable features under the 1988 Act, so that the purpose is that you prosecute a person, convict a person, and then the law will take its course.
Kulbir ji, jaise Justice Naqvi ne bola, obviously no law can be static. No good law should be static. It has to change with the changing needs of time. एक चीज जो मैं, though I'm a lawyer, but I want to put a proposition before you as a layman. ये जो कानून है, ये डील करता है corruption, रिश्वतखोरी, bribery, etc. But I was going through the definition clause of the statute. ये दोनों expressions वहाँ पे figure नहीं करते हैं. ना corruption defined है, ना bribery defined है. Though inference can be drawn from some other sections, I don't know. So can you throw some highlight on that these particular expressions?
No, as you said, no law can be static, or it's actually a cat and mouse game. What happens is that the criminals keep finding new methods, so the police and the administration tries to catch them. Laws are modified and improved to deal with that. And each time, then the other people, the wrongdoers, try to do some other criminal act. Now, the 1988 Act has been amended in 2018.
18, yeah, substantially.
And it was primarily because we signed India signed the Prevention of Corruption Convention of the UN in 2005. And then 2011 we ratified it. So this act had to come. The main point of bribery is that any kind of inducement, it need not be monetary. It can be in cash, it can be in kind, it can be in any way which induces the person to act in a illegal manner, which means that the government either loses money due to either commission or omission, both. So what happens is that this undue advantage has been given a very wide definition, उसमें ये है कि एक्सेप्ट लीगल रेम्यूनरेशन जो आपको मिलता है और जो सरकार आपको देती है, उसके अलावा कोई भी चीज़ अगर आप लें, चाहे आप एक हॉलिडे ले लें, चाहे आप कहीं विदेश में आपके बच्चों को आपकी स्कूलिंग वूलिंग या एजुकेशन ली जाए, या डॉक्टर्स कई बार फॉरेन जॉन्ट्स लेते हैं एट्सेट्रा, all that comes within bribery. And whoever is taking a bribe or giving a bribe, both are liable now, which was not there earlier.
Right. जैसे नकवी, जैसे कुलबीर जी ने बोला 2018 अमेंडमेंट, 2018 अमेंडमेंट का एक मेन जो थ्रस्ट था, जो अनड्यू एडवांटेज जो वो बात कर रहे थे, उसको इंक्लूड किया, एंड इट फाइंड्स इट्स मेंशन एट ऑलमोस्ट 30 प्लेसेस इन द एक्ट. आई वाज गोइंग थ्रू इट, आई वाज काउंटिंग इट. तो कुछ आप बताएंगे अनड्यू एडवांटेज के बारे में? वैसे कुलबीर जी ने बोला है, आप उसमें कुछ ऐड करना चाहेंगे?
2018 अमेंडमेंट वर्चुअली एड्रेसेस द इशू ऑफ पैसिव ब्राइबरी. इसलिए पैसिव ब्राइबरी को लाने के लिए दे हैड टू इंसर्ट अनड्यू एडवांटेज. अनड्यू एडवांटेज हैज बीन डिफाइंड एज एनी ग्रेटिफिकेशन अदर देन द लीगल रेम्यूनरेशन. आई एम अ पब्लिक सर्वेंट, मुझे सिर्फ अपनी तनख्वाह से मतलब है. अगर तनख्वाह के अलावा आप मुझे कुछ और भी देते हैं, विच कुड बी अ नॉन पेक्यूनरी बेनिफिट. मेरा बेटा को एडमिशन चाहिए अमेरिकन यूनिवर्सिटी में, आई डोंट हैव द मीन्स, अ कॉन्ट्रैक्टर का पेमेंट निकलना है, द कॉन्ट्रैक्टर सेज ऑल राइट, आई विल सिक्योर एडमिशन फॉर योर सन. Obviously that would come in undue advantage.
Monetary consideration involved नहीं भी है.
Absolutely not even a single paisa may have exchanged hands.
Right.
But this would be undue advantage.
Right.
Another section 7 capital A is a provision by which one public servant exercises his authority or his personal influence on another public servant. Even that is made punishable.
Oh, right.
कि भैया ऐसा है कि आप इनका काम कर दीजिए. अब या तो obviously district judge telling an additional district judge, or for that matter one judge telling his brother colleague कि भैया इनका काम कर दीजिए. तो ऑल दिस आज की तारीख में आर पनिशेबल.
तो खैर बहुत ही ओपन एंडेड है प्रोविजन. मुझे नहीं पता कि ये एविडेंस में कैसे ये प्रूव होंगी सारी चीजें.
ऑल दिस इज सब्जेक्ट टू एविडेंस. ऑल दिस इज सब्जेक्ट टू एविडेंस. बट एज फार एज स्टैच्यू इज कंसर्न, यू कांट find any fault with this statue.
Right. Well, it is time for a very short break. Please stay tuned as we will return soon. Welcome back after the break. You're watching our special show on selective landmark laws in the last 75 years. Today we are discussing a significant law, the Prevention of Corruption Act 1988. Kautilya, also known as Vishnu Gupta and Chanakya, through his ancient Sanskrit exposition on statecraft, economic policy and military strategy, suggested that to prevent and control corrupt practices amongst public officers, the law should be followed strictly. The corrupt should be given stringent punishments in the form of monetary penalties or jail. A corrupt officer and his dishonorable crime should be publicized so that it becomes a deterrent for others. That was the thinking. Let us now have a look at the parliamentary journey of this law.
The Prevention of Corruption Bill was introduced in the Lok Sabha on 23rd March 1987. The said bill was debated and passed in the Lok Sabha and the Rajya Sabha on 5th July 1987 and 8th November 1988 respectively. The said bill received the assent of the President of India on the 9th September 1988 and also it was brought into effect on that very date. The Prevention of Corruption Act was enforced by the Parliament of India on September 9, 1988. Let us now see some of the relevant passages from the parliamentary debates at the time bill was taken into consideration.
A comprehensive Prevention of Corruption Bill is being brought forward shortly to make the provisions of anti-corruption laws more effective. Government are also considering the whole question of jurisdiction and powers of the CBI in the drive against corruption.
I may submit that this bill has merely compiled the various provisions of the Indian Penal Code which were prevalent and the Prevention of the Corruption Act and the ordinance put together. As I could see, there is no doubt an enlargement of the definition of public servant. I do not see what is the rationale behind the enlargement of the public servant.
A salient feature of this bill is that it clarifies the definition of offences and penalties. The different clauses prescribe a minimum punishment of 6 months for various offences and 1 year in the case of criminal misconduct.
So let's get ahead with our remaining discussion. Justice Naqvi, we have discussed about corruption in the segment of governance amongst public servants, public sector. To my understanding, this law also applies to private individuals and commercial organizations. And there is also, to my understanding, a window of protection for the bribe givers. Can you please illuminate our viewers about the same?
You are absolutely right. It applies to private persons also. But the condition precedent is that this private person should be working for a commercial organization. एक ऐसा आदमी जो कि वाणिज्य संगठन के लिए काम कर रहा हो, be it in any capacity, चाहे वो प्रबंध निदेशक हो, चाहे वो कंपनी सेक्रेटरी हो, चाहे वो क्लार्क हो उस कंपनी का,
चाहे वो कंसल्टेंट हो,
चाहे कंसल्टेंट कोई हो, he should be working for that company.
ठीक है.
And further rider is that company should have been incorporated in India. It may be having its business elsewhere, but incorporation is a must.
इंडिया में होना चाहिए.
तो उदाहरण के लिए अगर कोई कंपनी इनकॉर्पोरेटेड आपके सिंगापुर में है और बिजनेस ऑपरेशंस उसके इंडिया में हैं, then I'm sorry, it cannot be prosecuted under the PC Act 1988.
That corporation would not be able to be
prosecuted. Absolutely not.
तो बट वो पब्लिक सर्वेंट जो इन्वॉल्व है उस पर्टिकुलर ट्रांजैक्शन में उसकी प्रोसिक्यूशन हो सकती है.
उसका हो सकता है, डेफिनेटली उसका हो सकता है, बट नॉट उसका.
ठीक है.
Now coming to your question regarding bribe giver, now 1947 Act granted protection. 1947 Act granted protection to the bribe givers. 1947 Act, old
right
Act.
From 47.
Yes, absolutely. I'm sorry. It granted protection. It granted protection to the bribe givers.
Right.
उसके बाद 88 का एक्ट आया.
ठीक है.
उसमें उन्होंने मेंटेन किया
उसी चीज,
हाँ, प्रोटेक्शन को, और 2018 में जाकर उस प्रोटेक्शन को उन्होंने खत्म कर दिया. दैट मीन्स आज की तारीख में ब्राइब गिवर हैज नो प्रोटेक्शन,
कोई प्रोटेक्शन
अंडर द पीसी एक्ट.
पर वो कुछ मैं ऐसा कुछ प्रोविजन पढ़ रहा था कि कुछ अगर विद इन फ्यू डेज,
एक हफ्ते के अंदर
आप कुछ ऐड करना चाहेंगे? हाँ, वो बहुत लिमिटेड सा एक विंडो है.
उसमें ये है कि अगर किसी ने ब्राइब दी है और वो एक हफ्ते के अंदर आके सरकार को बता दे या पुलिस को बता दे कि मैंने जबरन मेरे से ये ब्राइब ली गई है, तो आपके खिलाफ कोई एक्शन नहीं लिया जाएगा एंड एक्शन विल बी टेकन अगेंस्ट द ब्राइब टेकर.
वो जैसे जस्टिस नकवी ने कहा कि 7 डेज बेसिकली ना के बराबर ही हो गया
जी.
तो जैसे वो पहले जो प्रोटेक्शन थी 47 की, वो प्रोटेक्शन इज नॉट अवेलेबल फॉर्मिडेबली अंडर दी, बट स्टिल वो 7 डेज की विंडो है. आप जैसे कह रहे हैं,
पर ये बहुत ज़रूरी है क्योंकि ब्राइब गिवर्स आर एज मच रिस्पॉन्सिबल एज ब्राइब टेकर्स.
हाँ, बिल्कुल ठीक है.
और जो उनको प्रोटेक्शन थी वो नाजायज़ थी, तो अब वो जो चीज़ थी वो उसको सही कर दिया गया.
बिल्कुल ठीक है. और ये 7 डेज भी बेसिकली ये है इन्फॉर्मेंट बन गए या अप्रूवर बन गए या समथिंग लाइक, यू आर असिस्टिंग इन प्रोसिक्यूशन ऑफ द main accused, let's say.
That's right.
Kulbir ji, you have been at the helm of this statute, I would say, because you were heading the Anti-Corruption Bureau as well at some point in time during your service. तो आपके विचार में क्या practical challenges हैं जो एक investigating officer या investigating agency को face करने पड़ते हैं इस एक्ट के तहत, या एक prosecution agency को face करने पड़ते हैं? और साथ में मैं ये भी जानना चाहूँगा कि जो जिसकी प्रोसिक्यूशन हो रही है, जिसकी इन्वेस्टिगेशन हो रही है, वो भी आई एम श्योर कुछ चैलेंजेस फेस करते होंगे इस एक्ट के अंदर. तो क्या आप कुछ रोशनी डालना चाहेंगे उस पर?
आई जस्ट देखिए, जो सेंट्रल गवर्नमेंट एम्प्लॉइज या पब्लिक सर्वेंट्स हैं, दे आर कवर्ड बाय सीबीआई, सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन.
ठीक है.
but there is no CBI Act. There is only a Delhi Special Police Establishment Act of 1946.
Right.
तो क्या है, each state पहले जब एक ही political party पूरे देश में थी, तो everyone gave the provision के CBI is an all India organization. पर अब क्या होता है, जैसे कोई चीफ मिनिस्टर के ऊपर CBI के हाथ पहुंचते हैं, they rescind the permission itself, saying that CBI cannot act in our state. So there is no all India jurisdiction of CBI. Because the consent of the state is required. But in all states, there is an anti-corruption bureau which looks after corruption in state government employees, universities, which are not under the center, etc. अब एंटी करप्शन ब्यूरो में भी बड़े सारे प्रॉब्लम हैं, प्रैक्टिकल प्रॉब्लम. एक तो ये है कि इनका कोई डेडिकेटेड कार्डर नहीं है.
अच्छा.
तो इसलिए क्या होता है, दे कम ऑन डेपुटेशन
ओनली. तो सेंस ऑफ बिलोंगिंगनेस तो
पुलिस नहीं, दे डोंट हैव दैट मच एक्सपर्टीज. तो क्या है कि प्रैक्टिस मेक्स परफेक्ट. अगर आप केसेस करते रहो, आप जानते हैं ये लूप होल है, इसको प्लग करना है, ये जुडिशरी मांगेगी, हमें सारा हर इंग्रेडिएंट को प्रूव करना है.
ईडी की बात करें या हम सीबीआई की भी बात करें
जी,
तो वो भी ऐसा ही है. ईडी में भी डेपुटेशन पे आते हैं, सीबीआई में भी डेपुटेशन.
सीबीआई हैज अ वेरी डेडिकेटेड कार्डर एंड दे हैव गॉट एक्सपर्टीज. And in fact, at one time they used to have 90% conviction rate. Now it is still above 60%.
Right.
So CBI is a very professional organization.
This is an eye opener actually for me. Yes.
But ACBs are not that professional. Primarily because the staff, they don't have a core group, you know, which is trained in this, or which has gone to CBI. The idea of sending people on deputation to CBI was that they learn from CBI, come back and be the core in the state. But instead they are sent off to traffic or यहाँ वहाँ. तो जब तक वो एंटी करप्शन ब्यूरो में नहीं रहेंगे, that is one problem. Second is कि आजकल टेक्नोलॉजी का एज हो गया है. So everything requires, you require forensic auditors, you require examination of books of account, you require cyber specialists. So all these are there, but they should be merged into ACB.
Very valid point.
So that they can
very valid point, a very valid suggestion. Yes.
Third thing क्या है कि prosecution sanction वगैरह में काफ़ी टाइम लगता है. Prosecuting जो कर रहे हैं prosecutors, उनका एक मेन प्रॉब्लम ये हो रहा है कि आजकल, पहले क्या होता था कि if he has handled money तो phenolphthalein वगैरह यूज़ की जाती थी. अब most of these are done through wiretaps or through telephone tapping. कि मुझे इतना, now this guy is saying मुझे पैसा दो, पर इसको अगर हम, जब तक हमने होम सेक्रेटरी या जो कॉम्पिटेंट अथॉरिटी है परमिशन नहीं ली, इट इज इनएडमिसिबल. और जब एडमिसिबल है भी, तब भी लॉट ऑफ क्वेश्चंस आर रेज्ड ऑन इट कि प्राइवेसी
वो हो रही है, फोरेंसिक और ये वो बहुत चीजें.
तो इसमें क्या है कि सुप्रीम कोर्ट ने भी कहा है कि एक कमेटी होनी चाहिए, इज लाइक अ रिव्यू कमेटी सॉर्ट ऑफ. तो इन सब चीज़ों के लिए मुश्किलें हैं. और जब तक हम इन प्रोसीजरल चीज़ों को, और सबसे बड़ी प्रॉब्लम ये है कि ऑल्दो द लॉ सेज के 4 साल के अंदर हो जाना चाहिए, अभी भी 12-12 साल 10-10 साल के एंटी करप्शन केसेस आज भी पेंडिंग है.
वो तो
आजकल नहीं, पर ये है, या तो आप स्पेशल कोर्ट्स करिए और इसको निपटाइए, क्योंकि अगर आप 10 साल बात करोगे सब भूल जाते हैं या एविडेंस देने वाला गुजर जाएगा, तो हाउ कैन यू प्रूव द केस. तो ये बहुत सारी प्रैक्टिकल प्रॉब्लम्स हैं जिन पे गौर करना
पड़ेगा. और आई एम श्योर इम्प्रोवाइजेशन इज रिक्वायर्ड देयर.
जी.
वेल, फाइनल क्वेश्चन इज ऑलवेज फॉर आवर व्यूअर्स. सो वी हैव अ क्वेश्चन फ्रॉम Tanu Agarwal from Noida. Let us hear the question.
If a public servant allows his family members to use his official government car or laptop for their own personal work, can that public servant be held liable for criminal misconduct under the Act?
Mr. Naqvi, would you like to take this question?
The answer is no. For the simple reason that the person can be held liable only when the user fraudulently and dishonestly converts that property for his or her personal gain.
I see. So that fact has to be...
It could be a violation of a conduct rule. That's a different thing. but it will not attract the provisions of the 88 Act on mere use of a personal item.
Otherwise, every public servant would be under the four corners of prosecution. Well, the economic, social and cultural structure of our country is very strong. Still, corruption is considered to be one of the greatest impediments on the way to our progress. I'm sure our government's zero tolerance policy against corruption will make us see a corruption-free society sooner than later. Thank you so much, Justice Naqvi and Kulbir Krishan ji, for sharing your expert views and educating our audience so eloquently. Thank you so much.
It's nice to be a part of the show.
Thank you.
Thank you.
Well, that's all we have in the edition of the program. You can send your feedback to Sansad TV at sansad.nic.in. You can also connect with us on various other social media platforms. Thank you for watching. Goodbye and namaskar.